Assalamu alaikum. My name is Bilal Khan and welcome to another episode of Just Law on Ikra TV. As our regular viewers are aware, at Just Law we try to deal with all aspects of English law, in particular with criminal law, the defences available at law, and also the policies and procedures that the police have to adhere to. Now, at the bottom of your screen, there should be a number that appears, and our callers are urged to give us a call and ask any question that you may have. It may be on immigration, maybe on family law, maybe on criminal law, etc. And if you ask the question to me, bearing in mind that this is a live call show, there may be certain details that you may not be able to provide me due to the confidentiality reasons, etc. So in those circumstances, you can contact the control room and provide your telephone number and contact details to my colleagues. And what they'll do is provide me with the details, and I'll aim to get back to you within the next couple of days and advise you accordingly with your particular details looked at too. So sometimes there may be a need to look at your paperwork, look at your background details, etc. And those details, due to confidentiality reasons, some of our viewers may not want to share online. Or also, I may need to have some further details. So if there is particular advice that you need regarding your circumstances, then you can call us and we can speak to you on a private basis. However, our callers may call us and ask us generic advice regarding any aspect that they require assistance for. Now, for the last couple of weeks, we've been discussing criminal law and the rights and entitlements available to you if you are arrested, if you are suspected of a crime, or if you have been interviewed in respect of a crime. And we've talked about the police caution, we've talked about the rights you're entitled to, and we talked about the custody time limits, etc. Now, a caller did call us last week and they asked us to deal with driving offences, in particular in regards to failing to provide for a specimen for alcohol or drugs. Alternatively, general advice regarding driving, whether or not you need to provide a specimen for analysis at the roadside, and even if you are arrested in respect of the allegations. Now, dealing with that matter at hand, now the police can stop you for a check if they suspect a crime is happening, is about to happen. So for argument's sake, majority of police vehicles are equipped with what's called AMPR cameras, so automatic number plate recognition software. Now what will happen is, automatically when officers follow a vehicle, the computer system within the vehicle will pick up the registration number, and the police systems are linked to DVLA, to the motor insurance database. And what will happen is the vehicles will constantly be checked out, and then if there is a problem with a particular vehicle, it will alert the officers, and then the officers will probably stop that vehicle. The other reason they may stop the vehicle is if they notice that a vehicle has gone through a red light, or the occupants are not wearing a seat belt, or there is a deficient or defective brake light, headlight, etc. So if there is a crime that's happening and then they have a look at it, then they may stop you. Now, what's your rights at the time of stopping you? Now, first and foremost, a lot of people believe that they have to stop immediately. So as soon as the officers illuminate their lights or siren the system, then do you have to stop? Now, the highway code stipulates that stop only where it's safe to do so. So an argument or example of this is, if you are asked to stop the vehicle and there's no parking available, it's a busy street, traffic is traveling at 30-40 miles an hour, and then it's not appropriate for you because you'll be causing an obstruction. Under those circumstances, what you need to do is stop where it's safe to do so. Now, under those circumstances, you'd indicate to give a signal to the officer that you are aware of the officer's presence and that you are about to stop. And then whenever it's safe to do so, it may be at the next turning off, it may be at the next parking bay, etc. You need to stop for the officers. Now, if you fail to stop when requested to do so, that's a separate offence for which the officers may suspect you of, and they'll start following you, etc., if they believe that you're not wanting to stop for them. But generally speaking, majority of the people do stop for them. Now, what's the next thing? Now, do you have to exit your vehicle and go to the officer's vehicle? No, you don't. Now, if it's heavy traffic, etc., you will be urged to just remain in your vehicle, and the officers will conduct the further checks regarding the insurance, the MOT, the ownership, etc. And then once the officers ascertained all of the background information, they'll exit their vehicle and they'll attend upon you and they'll ask you further questions. Now, at that stage, you cooperate, you tell them your name, your date of birth, your address, and then at that stage, the officer may invite you to sit in the back of their vehicle. Now, at that stage, you can go into the back of the police vehicle, or you can question the officers as to what's the reason for my stoppage. Am I being arrested? Am I being detained? Can I have legal advice, etc.? So these are all legitimate inquiries or questions that you can ask of the officer. Now, if the officer suspects at that stage that you've taken either alcohol or drugs, etc., and as a result of that, you may not be conscious, or you may not, you may be over the prescribed limit, etc., then at that stage, the officer suspects another offence and then may ask you to provide a sample of breath at the roadside for alcohol, or alternatively a mouth swab. Now, at that stage, if you provide the sample and you are below the prescribed limit, or if no drugs are detected on your saliva, then at that stage the officers will eliminate you from that inquiry. They won't take no further action. However, they'll give you an advice, or they'll tell you the reason why they stopped you originally. So it may be no seatbelt, using a mobile phone, having an extra passenger, not having a seatbelt on, defective brakes, etc., etc. Now, at that stage, whatever the offence is, the officer will write down the nature of the offence, and they'll write down, or they'll advise you what action is proposed against you. Now, majority of the time, if it's a minor issue with a vehicle, they'll issue a warning letter and they'll say that, look, you've got defective brake light, here's a producer, and what you need to do is get the brake light rectified, or get the problem rectified, and then within 7 days come to the police station, provide us a slip to confirm that you've had the work done to your vehicle, and that'll be the end of the matter. Now, that's for minor offences. Now, if it's a case that is a bit more serious, such as your tyres are below the legal limit, or you was using a mobile phone whilst driving, etc., then at that stage they will caution you and they'll state to you that they're going to report you for a summons, basically meaning that they're going to provide this information to their sergeant or to the Crown Prosecution Service, and then they'll make a decision as to whether or not you will be charged for the alleged offence. Now, at that stage, the caution will be read out to you, and you'll be told you don't have to say nothing, but it may harm your defence. If you don't mention one question, something you later rely upon in court, and anything you do say may be given in evidence. So once you've read that caution, it's important to note that you don't have to mention any comment regarding the alleged offence, and then at that stage you can ask for legal advice. So it's important to note, if you have been cautioned for an offence, have been reported for a summons, then at that stage you have the right to remain silent regarding the alleged offence. Now, sometimes the officers will offer courses There'll be seatbelt courses available. There are courses available for driver retraining if they believe that you overtook a person when it was inappropriate to do so, etc. Then they'll offer driver courses, and then if you don't do a course within a particular time frame, what will happen is you'll be summoned to court for the original offence. Which brings me to the matter at hand, which is we have a call and then I'll come back. Assalamu alaikum.
वालेकुम सलाम। कैसे हो? तबीयत ठीक है आपकी?
अल्हम्दुलिल्लाह ठीक ठाक। आप कैसे हैं भाई?
अल्हम्दुलिल्लाह अल्हम्दुलिल्लाह। सॉरी, मुझे एक सवाल करना था।
जी
मैं ड्राइविंग कर रहा था ना,
जी
तो मेरी स्पीड थोड़ी ज़्यादा थी, 30 की स्पीड थी, थोड़े 40 के ऊपर था मैं।
जी
तो पुलिस ने स्टॉप किया है
जी
और उन लोगों ने बोला था कि आपके अंदर में 7 डेज के ऊपर लेटर आ जाएगा।
जी
तो क्या मुझे वो पॉइंट दे के
जी
या बाद में कोर्ट में जाना पड़ेगा, क्या करना पड़ेगा मुझे?
जी तो ये ब्रैडफोर्ड में था या किस शहर में था?
लीड्स
में था। ठीक है, तो वेस्ट यॉर्कशायर पुलिस जो है ना, उनकी रूल्स क्या हैं कि 10 माइल्स एन आवर वो लिमिट देते हैं। तो अगर 30 की स्पीड लिमिट पर आप 40 कर रहे थे ना, तो दैट्स विद इन द टाइम। अगर 41 42 कर रहे थे तो फिर डिफरेंट रूल्स है। लेकिन अगर अप टू 40 आप कर रहे थे तो फिर आपको जो है ना स्पीड अवेयरनेस कोर्स की ऑफ़र मिल जाएगी। ठीक है, अगर आपने पिछले 3 साल में स्पीड अवेयरनेस कोर्स नहीं किया तो फिर आप ये कोर्स कर सकते हैं। इसकी फ़ीस आपको देनी पड़ेगी, तकरीबन 80 पाउंड होती है इसकी फ़ीस। तो आजकल क्योंकि ये कोरोना वायरस चल रहा है तो ये ऑनलाइन होती है ये कोर्स। ठीक है, तो ये स्पीड अवेयरनेस कोर्स आपको करना है। तो अगर आपने सक्सेसफुली तकरीबन 3 महीनों में अगर आपने कंप्लीट कर लिया सक्सेसफुली ये कोर्स, तो फिर आपको कोई पॉइंट्स वगैरह नहीं मिलेंगे। ठीक है, तो फिर
बान तो नहीं करेंगे ना वो लोग?
नहीं। आप लाइसेंस कितना रसा हुआ आपकी लाइसेंस का?
मेरा 6 साल हो गया।
6 साल। तो कोई पॉइंट्स अभी है?
ना, पॉइंट्स नहीं।
कोई पॉइंट्स नहीं है। ठीक है, तो अगर 2 साल से ज़्यादा आपके पास ड्राइविंग लाइसेंस है ना, तो फिर आप 12 पेनल्टी पॉइंट्स ले सकते हैं। 12 के बाद जो है ना फिर आप डिस्क्वालीफाई होते हैं ना। तो क्योंकि आप
मैं टैक्सी ड्राइवर हूँ, तो मैं प्रोफेशनल ड्राइवर में काउंट होता हूँ ना।
जी,
तो वो लोग सबके लिए सेम है या टैक्सी वालों के लिए डिफरेंट रूल?
नहीं, टैक्सी वालों के लिए जो है ना सेम रूल्स है। इनफैक्ट अगर आपका केस कोर्ट में जाए ना, तो फिर मजिस्ट्रेट्स यूजुअली कहते हैं कि क्योंकि आप टैक्सी ड्राइवर थे तो इस वजह से आपको कानून जो है ना ज़्यादा सख्त उसको एक्सेप्ट करना चाहिए ना। तो स्पीडिंग की कोई जस्टिफिकेशन नहीं होती। इवन लाइफ एंड डेथ सिचुएशन में जो है ना वो भी आप नहीं कह सकते कि मैं स्पीड कर रहा था इस वजह से। ठीक है ना, क्योंकि रूल्स आर रूल्स। ठीक है ना, तो क्या होगा कि वो कंडीशनल ऑफर फॉर फिक्स पेनल्टी वो आपको भेज देंगे। अगर आपने स्पीड अवेयरनेस कोर्स 3 साल के अंदर आपने किया हो या 40 से ज़्यादा आपकी स्पीड होती है ना, तो फिर आपको कंडीशनल ऑफर ऑफ फिक्स पेनल्टी वो भेजेंगे। तो वो होता है 3 पॉइंट्स और 100 पाउंड फ़ाइन। अगर आपने वो एक्सेप्ट नहीं किया तो फिर क्या करेंगे कि वो आपको कोर्ट के सुमन्स भेजेंगे 6 महीनों के अंदर। तो 6 मंथ्स का टाइम लिमिट होता है। तो अगर 6 मंथ्स के अंदर उन्होंने कर लिया ना तो फिर वो ठीक है। अगर 6 मंथ्स के से ज़्यादा हो गया तो फिर उस वक्त जो है ना वो प्रोसिक्यूशन नहीं कर सकते।
जी।
ठीक है, जज़ाकल्लाह खैर। ठीक है, अस्सलाम वालेकुम। Just dealing with the question at hand, we have another caller. Assalamu alaikum. Sorry, call's been dropped. Now, the caller was just asking regarding a speeding offence. He'd been stopped in Leeds for an allegation of speeding. The speed was approximately 40, he said. Now, different areas have different rules. Now, Leeds is governed by West Yorkshire Police. Now, West Yorkshire Police have a rule of a 10 mile an hour limit. So, if the speeding has taken place on a 30 miles an hour zone, then up to 40 if your speed was, you'll be offered a speed awareness course. Now, it's important that you know that the speed awareness course can only be done once every 3 years. So if you've done the speed awareness course within 3 years, you will not be re-offered that course. However, if it's after 3 years, you'll be re-offered the course as long as you're doing less than 10 miles an hour above the limit. So on a 40 up to 50, on a 50 miles an hour zone up to 60, on a 60 up to 70, on the motorway up to 80. Now if you go 11 miles over the limit, then at that stage you're not eligible for the course. And then what the police will do is they'll send you a conditional offer of fixed penalty. Now that's for 3 points and £100 fine. Now if you accept that, then it's fine, that'll be the end of the matter. Your license will be endorsed with the 3 penalty points. However, if you don't send that back, or if you contest the speeding, or if you say I want to go to court, you'll receive a court summons or a postal requisition. And what will happen is the police have to issue that, get that signed and the charge authorized within a period of 6 months. So after that, they're statute barred. So it's always important whenever you receive any court summons, you have a look, consult with the solicitor and ask the solicitor, is this okay? Because sometimes we have cases where the police have charged a person, have authorized the charge, and that's out of the 6 months. Even if it's a day after, then technically the police and prosecution service have no jurisdiction to bring that allegation against you. So what I was explaining to the caller is if he's not done the speed awareness course within the last 3 years, he'll be offered that. You have a time frame of approximately 3 months to complete that successfully. If you don't complete that within the 3 months, then court papers will be initiated. Now a question that quite often comes to us is the officer said to us that we'll be eligible for this course. We forgot about responding to the letter and now we've got the court summons. Unfortunately, if the police have proceeded the matter to court, then that offer for a speed awareness course will no longer be valid, because the police have 6 months to prosecute a person, and if a person delays beyond that 3 or 4 months, and then there's going to be a risk that they're not going to be able to prosecute the person, and once they've done all the work to get all of the case file ready for court, then at that stage they say that, look, unfortunately we cannot re-offer this course to you because there's a chance that you may not do it or you may fail the course, etc. And for those reasons, unfortunately, you're not going to be eligible for that course again. So that's generally what happens. Similar thing for other driving offences as well. So seatbelt. Now if you've not done a seatbelt course within the last 3 years, which is an online course, it takes about half an hour, 40 minutes. Now if the officer stops you and you've done that course, you're not going to be eligible for that again. So then what will happen is the police will have 6 months to prosecute you, take you to court, or they'll offer you a conditional offer of fixed penalty. Now it's quite important, if you do not have a defence to the offence, then it's important that you accept the conditional offer of fixed penalty, because majority of the times that's more of a lenient sentence than the sentence that will be imposed by the magistrate's court. For argument's sake, if you've been alleged to have done 43 miles an hour and then the sentencing guidelines say between 4 to 5 points for that speed, however the conditional offer of fixed penalty was for 3 points. So if your case proceeds to court, you're going to look at a minimum of 4 points, which is one more than you were offered. And secondly, the fixed penalty is £100. Whereas if the case proceeds to court, then at that stage, the fine, there'll be a victim surcharge, which is mandatory in all cases that come to court, and there'll also be the prosecution costs on a guilty plea, which is usually £85. So if you add everything together, you're talking minimum of about £230–40, and maximum, it depends on how much you earn. The court is quite rightly can impose a financial penalty of 150% of your weekly earnings. So if you're earning £500 a month, that fine could quite easily go to £750 plus the costs, plus the victim surcharge. So quite often it'll be better for you if you've got no defence at law, then at that stage just to accept the conditional offer of fixed penalty. Now, if you have 9 points on your license, you're wanting to accept a conditional offer, unfortunately, the system will not allow you to, despite you accepting it and thinking I'll get 3 points. If it's a case that you've totted up to 12 points with this new offence, the conditional offer for fixed penalty will not be allowed to be given to you, and your court will automatically go to the magistrate's court. Now what will happen in the magistrate's court is they'll have a look at your guilty plea and they'll say, right, he's guilty, however, we should be disqualifying this person because he's a totter, and we should disqualify him for a period of 6 months unless exceptional hardship applies. Now, every case is judged at its own merits. Now, there may be one person who the magistrates agree that there is exceptional hardship in his case. However, there may be another person who the magistrates may say it's not, yes, there is hardship, but it's not exceptional hardship. So if you accrue up to 12 penalty points, it's always important to consult with a solicitor who specialises in road traffic offences, and then take advice from that person as to whether or not you've got grounds to argue exceptional hardship or not. Now, if you are in a similar position and you're watching the show, then you can contact the control room and get my details because I can assist you. I do deal with road traffic offences and exceptional hardship applications. Now, just before we received that call, we was talking about if the police stop you and then they suspect that you have either been taking drugs or alcohol, then what your right is. Now, there always has to be reasonable grounds to suspect an offence for an officer to go down that route and then to ask. Now, what we usually find in court paperwork is that the officers will say words to the effect of his eyes were glazed, his speech was slurred, and in the circumstances we smell alcohol from his breath and we believe that he was under the influence of alcohol. Therefore, the police quite legitimately can request a roadside breath test. Now, in other circumstances, and it's more and more prevalent in these days, the police will pull over a person and then they'll smell cannabis and they'll believe at that stage that we believe that the driver's been smoking cannabis, therefore we want a mouth swab. So what they'll do is they'll swab your mouth, and then if any cannabis is detected at the roadside, then at that stage you'll be arrested to provide a blood sample. Now, the same thing could happen for Class A drugs such as heroin, cocaine, crack cocaine, etc. Those can be detected at the roadside and then you'll be arrested for the offence and then taken down. Now, what happens if you fail to provide a specimen? Now, failing to provide a specimen for analysis is majority of the time a lot more serious than providing the sample, because if you fail to provide the specimen, there is a chance that you could have been triple the limit, 4 times above the limit, etc., because the police or the court will never know what your reading was. So the police and the courts tend to deal with you as a person who's had the highest level of intoxication. So then you're looking at a disqualification, a mandatory disqualification. In fact, it's going to be a lot more severe because of the fact that you've failed to provide and you failed to cooperate with the police with their inquiries at that stage. Now, as I've mentioned, you are entitled to consult with the solicitor. You can say to the officer, look, I just want to speak to a solicitor now and see whether or not I should be speaking to you or not. Because you've not been arrested at that stage, the officer will allow you to make that telephone call, and then at that stage you can ask on a quick phone call, do I have to provide this? And the solicitor will tell you yes. If the officer has suspected it because he's smelt it, or he believes that you're intoxicated because the mannerism of your driving, etc., or there's been a phone call coming into the police reporting a number of people drinking in a car, and then the driver has driven the vehicle. Sometimes it may be as a result of a public member's phone call that the officers attend, and then under that stage they do have reasonable grounds to suspect, and they will expect you to provide that sample. Now, there are cases when officers attend and the driver of the vehicle is not actually in the vehicle. So, for argument's sake, there's been an accident, a collision, officers attend afterwards, the driver's not in the vehicle. Therefore, do you have to provide that? Once again, if officers have reasonable grounds to suspect that you were the driver, they can come to you even if you was not the driver. It's important to know that even if you can prove that you never drove that vehicle, the offence is still made out and you can still be disqualified if the police can show we had reasonable grounds that he was the driver, we requested it from him, he said, look, it's got nothing to do with me, I'm not providing. You still can get charged for the offence. Now, what is reasonable grounds for the officer to suspect? So let's take an example of the telephone call. So a member of the public states there's an Asian male, he's got a black top on, and we've seen him drink, and he's gone straight into a car. The vehicle registration is XYZ, and he's travelling along this road. If officers attend, there's a vehicle bearing the registration number XYZ, there's an Asian male out with a black top on, and then they'll believe that he's the driver. Then at that stage they can request the specimen, and then if the person, even though he was not the driver at the time, if they have reasonable grounds to suspect it was him, he fails to provide that, then you can still be charged and disqualified from driving and convicted of this offence. So it's quite important to know at that stage that it doesn't make a difference whether you was driving or not. It's whether the officers have reasonable grounds to believe that you was driving and that you are above the limit, and then at that stage they'll request the sample from you, and if you fail to provide it, you're still guilty of that offence. Now what happens? There's different procedures. If you are suspected of drink driving, then the officers will have a breathalyzer kit. Now they'll show you the kit, they'll open the kit in front of you, make sure it's a sealed kit, etc., and they'll provide you the instructions. And when you blow into it, there'll be a reading, and then depending on what the reading is, if it's below the limit, then that's the end of the story. If it's above the limit at that stage, the officers will caution you, arrest you, and take you to the police station. Now, because the road side kits are not accurate enough to bring the prosecution, when you are taken to the police station, booked into the police custody by the custody sergeant, you'll be taken on an intoxilizer machine, which usually is in the custody area, separate area, and then there'll be a room with a camera inside it, or officers will activate the body-worn footage on their clothing, on their vest, and then they'll go through the drink driver's procedure. Now the procedure is a MGDDA form. Now that form will be completed. They'll ask you a series of questions about were you driving, what vehicle you were driving, had you had anything to drink, have you had anything to eat, have you had any alcohol, any drugs, etc. So they'll go through a list of questions and they'd expect you to cooperate and answer those questions. Now once again, you're not compelled in answering questions. You can always remain silent, you can go no comment, etc. You will not be charged with the offence as long as you provide the sample. Now, once they're going through that, the officers have to advise you of the correct procedure to provide the specimen. And for drink driving, if you use the example, there'll be a machine, the line intoxilizer machine usually, and there'll be a mouthpiece. They'll expect you to blow for about 3 seconds, continuous blow within the machine, and then it'll generate a reading. Now sometimes people can't breathe that hard or that long, and then the officers will give another opportunity, and unfortunately if you do not provide the sample within a given time, and then you will be charged for the offence. Now there is defences available for this. Sometimes if the person suffers from asthma, cannot provide that, then that's a defence. Now sometimes, for the example of when you was not stopped actually driving the vehicle, if you was stopped thereafter not seen to be driving the vehicle, there's a case of whether or not there was any post-driving consumption of alcohol. And then when you're going through the MGDDA form, they'll ask you whether you've drank alcohol before the episode of driving, after the episode of driving, and they'll ask you what quantities, etc. And then at that stage, if it's a case that you believe that you was under the limit at the time of driving, and then you've had other stuff to eat, drink, etc. afterwards, then it's a case that you may have a defence on the post-driving consumption, and then it's for the prosecution to prove, and then the defence will be required to provide a toxicology report, etc. From a doctor to say that, yep, this is the instructions, and this is what the reading should have been, and this is what the reading is. Now, insofar as drug driving is concerned, more or less a similar procedure. However, there's no breath test. Now, at the roadside, you'll be asked to give a sample of your saliva, etc. There'll be a mouth swab, and what the officers will do is ask for your consent to give a mouth swab, and then in a few minutes that mouth swab will detect any kind of drug on it, and if there is any drug detected, then at that stage you'll be arrested, cautioned, taken down to the custody suite, and once you're taken down to the custody suite, then at that stage a nurse will be called in, and you'll go to the intoxilizer room again. The camera will be activated, and then the nurse will request to take your blood sample, and then 2 lots of blood will be taken from you. The blood samples will be kept. One sample will be kept, and the other sample will be given to you, and then the officers will state that this is for your own records if you want to have your own examination. Now we're going to go for a short break, and after the break I'll continue with the drug driving procedure. I'll see you at the other side of the break.